Okay, we have everyone ready to go here. Mr. Spivey, it's my understanding that you are here on behalf of the appellant. And if I'm correct, I would ask you if you'd like to reserve time for rebuttal.
Yes, Your Honor, I'd like to reserve 5 minutes.
Okay. Mr. Donovan, is anyone going to be speaking besides you on the other side?
No, sir. I'll be representing both appellees for purposes of this oral argument.
Okay, thank you very much, counsel. Mr. Spivey, with that procedural hurdle, so to speak, jumped, we will turn to you and allow you to begin your presentation. Thank you, counsel.
Thank you, Your Honor. As you say, I'm representing the appellant, Brittany Smith Stewart, as trustee, the daughter of the decedent in this case, and the sole residuary devotee in her capacity as trustee of two trusts under the will. The parties agree this is a case of first impression, and the court will be happy to know there are no factual issues. There's no testimony to consider. It's a pure issue of law. The appellant contends that the non-resident pretermitted spouse of a non-resident decedent has no enforceable rights as a pretermitted spouse in specific Florida real property. We're contending that Georgia law should determine the pretermitted share in this case, because like Florida, Georgia has a pretermitted spouse statute that protects against inadvertent disinheritance. A determination under the Georgia statute would be that the pretermitted spouse is entitled to a percentage of the probate estate. That determination by a Georgia court would not affect title to the Florida property or disposition of the Florida property. Florida and Georgia have the same scheme. Basically, the pretermitted share is a percentage. You determine the value of the probate estate, and the pretermitted share is a dollar amount. And
I don't want to interrupt you, but I would like to find out, this was a motion to stay originally, right? The ancillary proceedings, and that was denied. Then you ended up with a ruling, correct?
Correct.
And theoretically, the motion to stay was filed because it was a motion to determine beneficiaries pending in Georgia.
Yes, Your Honor.
And a similar argument would have been made about a choice of law. Did that Georgia case or motion ever get resolved?
Your Honor, I do not think it has been.
Because there could be an O. Henry ending. If Georgia did the same thing that the Florida law appears to require, we've got no conflict. You're not gonna prevail. But if Georgia is still up in the air, then what we do here today might be significant for you.
I think what is up in the air there, Your Honor, is a question of whether or not the surviving spouse waived pretermitted share rights. I don't think, if she did not, then I think the Georgia court would probably proceed to determine a pretermitted share under Georgia statute.
So the next question I was going to ask you is there any suggestion in our record of a pre or post marital agreement between the relevant parties?
No, that it was conceded, I think, by all parties that there was no marital agreement involved here.
So there may or may not be some sort of a waiver in Georgia, but that's not something we're going to worry about here today.
Right, that's correct, Your Honor.
I got you.
So there's been an argument that Florida has this strong public policy in favor of surviving spouses. And the truth is that with respect to pretermitted share, Florida has no strong public policy whatsoever. And in favor of non-resident spouses, in particular, Florida has no strong public policy.
Well, let's put the public policy perception argument aside just for the moment. Explain to me chapter 731.1055. That seems to be unambiguous on its face. Aren't we duty bound to give every statute its plain and ordinary effect?
Well, if determination of a pretermitted share was a disposition of real property, that statute might apply. But our
Okay.
contention is the statute has no bearing on this case. In fact, the appellee in her brief states that, quote, "No one is arguing that a pretermitted share is a disposition of real property." Well, if it isn't, why does this 731.1055 apply?
Well, obviously, let me just follow that argument. When you file an ancillary administration, you allege in the petition, there's real property or some asset in the state that requires us to file an ancillary administration to get an order of disposition. So
Correct.
you're seeking an order, or someone's seeking an order from the Florida Probate Court down in Sarasota County to say who the owner of that Longboat Key condo is, so it can be disposed of under the estate. So you are determining the ownership of real estate the way I look at this, but I could be wrong. I make plenty
Yeah,
of
I don't
mistakes.
think you are, Your Honor. What is being determined in an ancillary proceeding is that the will being admitted to probate is valid and admissible to probate in Florida, and that the dispositions it makes are legal. In other words, there's no problem. We're not devising this to Al Qaeda or the Ku Klux Klan. So
Well, and you can't
So there's
stop
no-
anyone from giving it to them if you want to.
well, there's no question here that we have a valid will and a valid residuary.
The will was
divide.
never changed after the death of the spouse in question. The will was the same. That's maybe that spouse is alive. I should have said the will was never changed after he got remarried. He got divorced, remarried, never changed his will. Otherwise, you wouldn't have a pre-admitted spouse situation. And there was never a new will made. There's no post or pre-marital. There's nothing to exclude the second spouse, and therefore you apply the pre-admitted spouse statute. You're just saying we go by Georgia law, not Florida law, because it's not a real estate.
I'm saying even if we went by Florida law, that the pretermitted spouse statute, if you read the plain language of it, doesn't dispose of any property at all. It just determines the right of that spouse to a percentage of the probate estate. And that percentage can be satisfied by the personal representative. In fact, in this case, if this property in Florida was less than the pretermitted share, the property could be distributed 100% to the pretermitted spouse in partial satisfaction.
Well, was there a similar case in 2006 by name of Saunders v. Saunders, dealing with a Colorado resident that the legislature sought to override a different DCA ruling? And would we be following a decision contrary to the statute that the legislators sought to impose their own will to correct in their mind?
I don't think so, Your Honor. I think the changes that were made in response to Saunders missed the mark. If the legislature wants to provide that Florida's pretermitted share statute applies to non-resident pretermitted spouses, it should say so in the pretermitted spouse statute. That's what should be amended. I don't know why there was an assumption at least by the appellee's counsel or by the ancillary personal representative that the pretermitted share is a disposition of real property, when it clearly isn't when you read the statute. It's just a determination of an interest in the probate estate to be satisfied at the discretion of the personal representative or upon order of the court. So I don't know if the public policy argument for application of the Georgia statute doesn't concern you, I will move on, but our position is, Florida gives surviving spouses rights in the elective share and exempt property and in the family allowance. And in every case, they specify that applies to the spouse of a Florida domiciliary. This statute doesn't say anything one way or the other. And that's why it's before the court. And that's what we need a decision on. But I think that there's clearly no public policy argument in favor of Florida intending to take care of non-resident pretermitted spouses of the other 49 states. I just don't think that's what we're about. And as I said, even if Florida law determined the pretermitted share, it doesn't determine interest in any specific property. I mean, the judge in this case said, okay, we're going to apply the Florida intestate pretermitted spouse statute. We're going to apply the Florida intestacy statute, and the widow gets 50% of this condominium. Well, that's just flat wrong. It's pretty apparent, and I cited in the reply brief, Florida statute 733.805 is part of the probate code, which provides that the pretermitted spousal share is satisfied first from any intestate property, which there isn't, and if insufficient, from the residue of the estate. And unlike dower rights, and homestead rights, neither elective share nor pretermitted share give the holder of those rights any interest in specific property. The appellees are presuming, on the one hand, that determining the value of pretermitted share equates somehow to a disposition of real property. But as I said, they say no one is arguing that a pretermitted share is a disposition of real property. So why does this 731.1055 apply to this case at all? I think the only real disposition of real property involved in this case is the plain vanilla residuary devise of the probate residue to the appellant. And the pretermitted spouse has got only a right under the Georgia statute or the Florida statute to a share of the entire residue. And that determination is within the Georgia probate court's jurisdiction. They are the domiciliary administration. And the court here erred in finding that there was a Florida residuary estate in an ancillary administration. That's just not the case. There's only one residue under any will. And the residue here is going to be disposed of in the Georgia probate proceeding. All the ancillary does is say, okay, this asset over here in Florida needs to be added to the residue because it's not specifically devised to anybody. So there is no residuary within an ancillary estate. If it's not specifically devised, the asset becomes part of the domiciliary estate. That's what Chapter 734 makes clear. I would say that the appellees can't point to any case holding that this pretermitted share statute confers any right in a pretermitted spouse to any specific property, and specifically a pretermitted spouse in another state. I mean, here we have a Georgia decedent and a Georgia spouse.
Well, I sense the frustration here, but the language of the pretermitted spouse statute, I'll read it to you. I'm sure you've read it 1,000 times. When a person marries after making a will and the spouse survives the testator, which you agree with that we have, the surviving spouse shall receive a share in the estate of the testator equal in value to that which the surviving spouse would have received if the testator died intestate. So you calculate the value as if they died intestate, and they're only alleging an interest of the condo. They're not alleging an interest of anything located in Georgia. There was nothing else in Florida. There was no homestead technically in Florida, but if the person died intestate, they'd have to split that with the surviving lineal descendants. Is that true or false?
Well, what that argument means is that you could have pretermitted share determined in multiple states if the decedent owned real property in multiple states other than the domicile.
We don't have that case, so let's not worry about it.
I know we don't, but it's the reason why Florida shouldn't be determining pretermitted share.
But isn't that a problem with the legislature? If there was a problem, the legislature would have to say, except if there's more than one state involved, or accept this or accept that. I mean, normally when you make a will and you get remarried, the first thing you adjust is a new will. You do
Correct.
something or you get a waiver. This person went about their merry way and either forgot, most likely, or didn't have time. I'm not sure what the circumstances were, but left the pretermitted spouse holding the bag. So we have to presume the legislature now steps in and makes a decision what happens to the property in Florida. So that's where I'm coming from.
Well, and as I said, if the legislature wants to provide that non-resident pretermitted spouses have rights in Florida ancillary real property, they should change the pretermitted spouse statute to make that clear. Because all they've said here is that
We
Florida
can't
law
rewrite, we can't, it says a surviving spouse. It doesn't say a surviving resident spouse. It doesn't say any of that. So we have to deal with what we have. I can't rewrite the law. I don't think any courts are permitted to do that. Your remedies with the legislature, by the time you got to the remedy, it's kind of too late. They're not going to make it retroactive, or you leave it to us to do something and then take something up to the Supreme Court if necessary.
Well, I think my major point on that is that even if the Florida statute applied to a non-resident pretermitted spouse, it doesn't give her the right to an interest in this Florida condominium.
Because now you're at 15.
Okay.
Okay,
You've answered my question. If you want to reserve, that's up to you.
sure, I'll reserve my
Okay.
5.
Okay.
Mr. Donovan, you may proceed.
Thank you. May it please the court. As I mentioned at the beginning, my name is Chris Donovan. I'm here on behalf of the appellee, Dresden Brunner, who is the ancillary personal representative. And rather than divide time with David Wallace, who represents the other appellee, Cynthia McGee Smith, who is the surviving spouse, rather than divide our time on when we have such a narrow issue, I will be taking the lead. I do want to emphasize that the issue before this court is really quite narrow. And it's simply, does Florida law control the validity and effect of a foreign wills disposition of Florida real property? And the answer to this question resolves every other issue in this case, including whether or not the Florida pre-termitted spouse statute applies. And I want to emphasize for a moment that Florida law does not apply because the Florida pre-termitted spouse statute applies. It's the other way around. At first we looked at, does Florida law apply? And then if it applies across the board. And that would include the pre-termitted spouse statute. And the answer to whether or not Florida law applies is really quite straightforward, because the Florida legislature gave us very specific, unambiguous directions when it enacted 2 statutes, or revised one and enacted a new statute. And the answer is based on the nature of the property being disposed of by the will. If it's personal property, then 731.106 provides that the court looks to the will's, the decedent's choice of which law applies. If it's real property, then the 731.1055, as this court mentioned, would apply to determine the validity and effect of the disposition of that real property. And that's what we have here. We don't have the disposition here is not the pre-termitted spouse's rights. The disposition here is the fact that the will disposes of Florida real property, a condominium, to 2 trusts via a residuary clause. And it doesn't matter that it's a residuary clause or it's not a specific devise or anything like that. In fact, the Florida Supreme Court decision in Via Putnam actually involved a situation that was devised to a residuary clause, not a specific devise, and it applied the pre-termitted spouse statute in that scenario. It wasn't a foreign will, but again, once we determine that Florida law applies because of the disposition of real property in the will, then it applies across the
Start with
board.
that argument. I think his response is it doesn't dispose of real property. It's a pre-termitted spouse interest. What's your response to that?
It's conflating the analysis, Your Honor. Again, no one is arguing that Florida law applies because there's a surviving spouse. Rather, Florida law applies because of the nature of the property it's being disposed of in the will. That is real property. If we didn't have a surviving...
Well,
Sorry.
tell me if I'm wrong. At common law, the sovereign disposed of the lands in its realm. The
Correct.
King of England didn't tell the King of Spain what to do with its property under any circumstance. So you didn't really need a law saying the law of Florida applies to disposing of the land in Florida. I mean, but we have a law to make it doubly clear. The King of England can't tell, or the governor of Georgia can't tell the state of Florida what to do with its real estate. You got to follow Florida law. That's kind of a simple way to put it, but is that correct?
That is correct, Your Honor. Yes. I mean, what you just announced is the common law doctrine of lex loci re sate, And that
That's
is
right,
that,
but I didn't use Latin like you showing
yeah,
off.
I've been practicing. I used the internet to make sure I had the Latin correct, actually. But it basically means that the law where the thing is located controls the descent, alienation, the interpretation, et cetera. And all the legislature did when it enacted section 731.1055 was to approve of the common law, that Lex Loci rule, including the common law analysis that's provided for at the Supreme Court's decision in Trotter versus Van Pelt, where it said that the law of Florida applies absolutely to real property. That's why that's why probate courts have in rem jurisdiction over the property.
What about
or
that
any-
Saunders case? What about Saunders that's recognized Colorado law over Florida law, and the legislature got a little bit upset with that?
Correct, Your Honor. The Saunders case was based on a different statutory language when 731.1062 actually referred to both personal property and real property. And so the court said, well, they viewed that as a repugnance to the common law and a complete rejection of it. And then in 2016, the Florida legislature removed the reference to real property from 731.106 and instead enacted 731.1055, which, as Your Honor noted, didn't really need to be enacted because that's already provided for by the common law that's been in the common law since the beginning of the state, but it was being doubly sure. And as the common law provides that because Florida law determines the disposition of real property in a will, it doesn't really matter what happens in Georgia. Rather, as the Trotter versus Van Pelt case said, the court looks at it as if it's being devised from a separate state-specific will. In other words, the opposing counsel's argument that there can only be one residuary estate is not entirely accurate under the Trotter versus Van Pelt decision, because the court is looking just at how do you dispose of the real property in Florida, or how does the court dispose of the real property in Florida, and is that disposition in the will legal under Florida law? And the court and the legislature provided for that should be the way the analysis begins. And again, the pretermitted spouse statute only comes into being once the court determines that Florida law applies. If there was no surviving spouse, let's look at a couple hypotheticals. Let's assume there's no surviving spouse. It doesn't change the analysis. There's a real property here. Florida law is going to apply. The nature of the property is what controls. If the Florida law said something like, maybe Florida law totally prohibited trust, period, then the disposition to the trust in the Georgia will would be invalid under Florida law.
You still have an intestate succession.
Correct, Your Honor. It would be invalid at that, and the intestate succession would then just be disposing of that one property by Florida intestate rules. And maybe that's an extreme example. Let's consider another example or hypothetical. Let's say that Florida had a longer creditor's claim period for creditors than Georgia did. So a creditor could go to Georgia, and maybe they're late in Georgia, but then they come down here in Florida, and they would be timely if Florida had the longer creditors period. Then, because this involves real property, the Florida creditors period would apply for the longer period,
Well,
and thus
yeah,
the
course.
creditor would be in. I'm sorry.
Right. They'd only be timely if there was an ancillary estate that has its own rules. So
Correct, Your Honor. But the point
No,
is that the fact. Sorry, Your Honor.
no, I understand. It's a good that's a better analogy.
But the fact that there is a surviving spouse does not dictate whether or not Florida law applies. What dictates whether Florida law applies is the fact that the will is disposing of real property that's located in Florida. And once the trial court made that determination, albeit, and I argue correctly, then the court has to look at how does Florida law apply? Well, Florida law has a pretermitted spouse statute that's quite broad. In fact, Florida's pretermitted spouse statute is an outgrowth of the Florida's law on dowries, and has been around for, again, since the beginning of the state under the common law. And in fact, prior to the creation of the statute in 1933, a will was completely invalidated for all devices if somebody married after making the will, unless they republished it. And in 1933,
we don't have any sort of a public policy analysis here, do we? Is any of this related to a public policy analysis?
No, I don't believe that it is. I'm simply explaining what the common law was, and insofar as there is any public policy argument there, it's when the legislature created 732.301 or a version of that in 1933. And 732.301, which is the pre-terminated spouse statute, specifically provides a person marrying after making a will. If the legislature, when it created the statute, had wanted to limit it to domiciles, as opposing counsel's argument wants to do, they could have added a phrase like a person who dies domiciled in Florida. In fact, they specifically did that in the elective share statute and the family allowance statute, but they didn't do it there in the pre-terminated share statute. And therefore, the omission has to be presumed intentional. Opposing counsel in his reply brief disagreed with the application of the canon of interpretation that the omission of a statute is presumed intentional, because he argued that the elective share statute, the pre-terminated share statute, and the family allowance statute were enacted all at the same time in 1974, modeled after the Uniform Probate Code. With respects, the court should reject that argument for two reasons. One, it's not entirely clear whether he's accurate. It's a conclusory statement in his reply brief that he doesn't actually provide the legislative history for. And in fact, I would direct the court's attention to Grenier's Estate versus Grenier's Estate, which is a 1982 Supreme Court case that goes into the whole history of the pre-terminated share statute from the common law to its original enactment in 1933, not 1974, but its original enactment in 1933. And the language, it quotes it full, is very similar, almost linguistically identical to the way the current statute reads, which simply reads, a person who dies domiciled in Florida. But even if opposing counsel's legislative history regarding it being an outgrowth of Uniform Probate Code is correct, the fact that it was all enacted in the same legislative enactment, but the legislature omitted a domicile limitation from the pre-terminated share statute would only further bolster, the canon that the omission must be presumed intentional. Now, I know opposing counsel has identified many reasons why there should be a limitation in there. And as Judge Valenti pointed out, those are probably better directed towards the Florida legislature, because the Florida Supreme Court in two separate cases, one of them Villa versus Putnam and Garner's Estate versus Garnier's Estate, both have refused to judicially expand the pre-terminated share statute by adding exceptions or adding words. In fact, the Fifth District Court of Appeals in re Estate of Dumas case has specifically said that the pre-terminated share statute applies absolutely whenever the conditions are met, and there's no exceptions, none of its specific exceptions apply. And here, none of its specific exceptions apply. Rather, it involves a person who passed away without after making a will and then leaving a surviving spouse. Therefore, because, and again, after this court writes an opinion, if the legislature wants to go back and agrees regarding the public policy issues, the legislature can certainly do that. But as it stands now, this court must affirm the trial court, because Florida law applies given the nature of the property being real property and 731.1055's plain language. And that because Florida law applies, then the court has to look how Florida law applies. And here, the how is there's a surviving spouse. Therefore, you have to look at the pre-terminated share statute. And the pre-terminated share statute says if the surviving spouse has not been provided for in the will, then she receives her intestate share, which here would be half of whatever real property exists in Florida. The fact that there's only a condo is irrelevant, because if there had been 50 condos, then it simply would have increased her share of her intestate share under the pre-terminated spouse rule. But here, there's only a condo, and so the trial court did correct by giving 50% of an interest in that to Ms. Smith. Therefore, the court should affirm, because it's correct under the plain language of both 731.1055 and 732.301. Thank you, Your Honors.
Thank you, counsel. Pardon me. Mr. Spivey, your 5 minutes remains for rebuttal, sir.
Thank you, Your Honor. Well, we go back to 731.1055, which applies only to disposition of Florida real property. And the question is how you apply that? Well, under our facts, there are only two possible dispositions. One of them is the residuary clause of the will. And there's no question, nobody has questioned whether that is legal under Florida law. It happens every day. So it's a pour over devise to trustee of a trust. That's under Florida law, a valid disposition. The other possibility is that, well, since Florida law applies to disposition, we'll have to say that the pretermitted spouse statute is a disposition. So we're going to drag that in there and take that into account. Well, our position, I think, is pretty clear that that just because Florida law applies doesn't mean the pretermitted spouse statute applies, because it doesn't make a disposition of real estate. It doesn't affect the disposition of real estate, period. The Saunders case, as I said in the brief, I think is not relevant here because it was a decision based on a statute that no longer exists. I think it was correctly decided by the court in that case. That's why the statute was changed. But and the mention of Trotter v. Van Pelt, well, that's a seminal case, and what it basically says is that, or said in that case, was that even though the court of another state had determined a will to be invalid, the validity of that will could be litigated in Florida because it disposed of Florida real property, and the court here said it's validly executed under Florida law, and therefore that's what is meant by Florida law applying to a disposition under a will. If the will is valid and if the devisee or the devise is valid, then that should end the inquiry. Florida did in 1974 adopt pretty much wholesale a lot of the Uniform Probate Code. And I don't think it's correct to assume that since they didn't put domiciliary in the pretermitted share statute, that it was a matter of intent, because they moved over the Uniform Probate Code sections, and it doesn't say that. So it's not like they thought about it and then removed it. So it's not, I think, really relevant. But I think I have pretty much beaten this to death, so I won't go any further. I'll just rest on the arguments in the brief and ask that you reverse this decision.
Thank you, counsel, and we thank you for the first time today. Counsel didn't use the entirety, both counsel didn't use the entirety of their time, and it's much appreciated as we roll on to this afternoon and we have one more case going. We wish you all well, and please be safe in these times.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, gentlemen.